welcome to Oil and Gas. Today we will talk about executive rights. And at the simplest level, executive right is the right to determine what happens with the oil and gas on your property, how it is leased, what kind of royalty and bonus you get. Now, normally that comes with the mineral interest. So normally that right to grant leases just belongs to whoever owns the mineral interest on a piece of property. But we sometimes have to separate this idea out conceptually from the mineral interest when it gets separated from the mineral interest to some extent. So there might be a circumstance in which you would give somebody a quarter mineral interest, but you say, I don't want you choosing how to lease this property, so I'm going to keep the full executive right. So you get the quarter mineral interest without an executive right, and I've got the executive right for the whole property, but just 3/4 of the mineral interest. So that's why we have to talk about it conceptually when it gets separated from the mineral interest. Normally, we just assume it goes along with the mineral interest. Okay, so for a fee simple owner, you own the minerals, as we know, in Texas because of some combination of ad coelum and rule of capture. And so you have that executive right. Similarly, if you own the mineral interest, so let's say you bought the minerals from someone, that comes with the executive right. That's the default. So you have the right to choose how to lease your minerals. We see more rarely this idea of somehow an executive right, the right to determine how a property is leased, that gets separated entirely from the mineral interest. That's called a naked executive right, because you just have the right to determine how it's leased, but none of the actual ability to develop, none of the actual minerals. So typically you're not going to get many of the benefits of that lease. Now that can create serious problems, and courts tend to be skeptical, as we'll see, of that kind of naked executive right. All right, so what are non-executive mineral interests? So this is a mineral interest where the executive right has been stripped out of it. Now, in a way, you could think about royalties as a non-executive mineral interest, because remember, the royalty is a share of production, but it doesn't include any right to lease that minerals that it's drawn from. So if I have, a non-participating royalty interest that is say a 1/10 share of all production that came from that land, that could be worth a lot of money. That's almost as big as, the old default landowner's interest, which is 1/8 royalty. But the problem with my 1/10 non-participating royalty interest is I have no right to lease that property. And so there can become a problem because I'm going to get a lot of production if there is production on that land, but I don't have any right to actually do the leasing to an oil and gas company. So that we see this arise with non-participating royalties. Also, potentially with overriding royalties. Remember, those are created out of the leasehold interest of the lessee, the oil and gas company. So it might say, I'll give a 1/16 to you if you drill it, et cetera, but then I've got the well back, and that overriding royalty doesn't have the right to determine how the property is developed. The lessor's royalty, we don't normally think about it this way, but it's also a non-executive mineral interest. And the reason is because, yes, of course, the lessor, before they leased, had the right to lease the property and determine how it was produced. But once they've granted the lease to the lessee, to the oil and gas company, then they lose that ability to determine how the property is produced. They can't lease it because it's subject to a lease. And they also can't determine how, exactly when the oil and gas company drills or otherwise. They might have some influence on that by, arguing with the oil and gas company, threatening to sue, actually suing. But fundamentally, that right is at that point held by the oil and gas company. They have the ability to determine how it is produced. Okay. So why would you sever executive right from a mineral interest? There's a lot of possible reasons, but here are some of the common reasons that you see. One is to protect a surface interest. So you might say, let's say you had a ranch or you were a farmer and you wanted to make some money from the oil and gas underneath your land. You weren't quite ready for an oil and gas company to come on and start drilling. So you say, you know what, I'll sell half of my mineral interest to somebody who's interested in developing oil and gas. But of course, we know that that person could go ahead and lease that mineral interest right away. Here in Texas, you can, with a half mineral interest, go ahead and lease it. And all that would be owed to that, rancher or farmer would be an accounting on that other half. So they would have to get, their half of the profits after the oil and gas company finished developing. Now, obviously, that's potentially a problem because the whole reason that the rancher or farmer didn't just lease was because they weren't ready to have some oil and gas drilling on their land. And so it's a problem if when you sell that half mineral interest, that person who now owns 50% of the minerals can send an oil and gas company on your land at any time. So one reason that we see executive rights be severed is they say, look, you can have the half mineral interest, but I'm going to determine the timing of when this is leased and how it's leased. So I'm going to keep 100% of the executive right, and I'm just going to give you 50% of the mineral interest. All right. Another reason you might sever executive rights is that it's simply part of the bargain. So, you might say, well, especially back in the old days when it was typically a 1/8 royalty, you might say, what's the benefit of having the ability to lease or not lease? That's, everybody's going to lease for basically the same amount. Okay, that was an oversimplification even back in the day because you could have different amount of bonuses and different timing about when you leased. But so there's always some discretion that goes with the person that's able to sign a lease, and that is important. And so you might say there's just some inherent benefit in being able to be the one who gets to choose how the property is leased. And so, maybe you gave that 50% mineral interest with no executive right. You sold it in part because you wanted to protect the surface, but maybe it was also in part because you just wanted control over how it was leased. That was worth something to you. Okay, another reason that sometimes you sever the executive rights, and we'll talk peripherally about one of these examples today, is to ensure that somebody can bargain for the interest. So imagine, you have 3 children, and so you have a big property and you have 3 children, and you want them all to inherit your oil and gas equally. Now, obviously, you can't just split up your large property into 3 equal portions because they might have different amounts of oil and gas. So you want to give 1/3 of the oil and gas to each of those different children. So you give an undivided third in the land. Okay, what's the problem with just doing that? Well, one problem is that now you've created a problem when they try to lease it for oil and gas because they're going to have to all agree to lease it to an oil and gas company, and the negotiations may break down. They may break down between some of your kids may not want to lease at the same time. There can also be a problem if they all lease to different companies. There can be, friction between those companies if they want to come together with a joint operating agreement to operate that property. So it can be a big challenge. So one thing you could do is just give 1/3 of the mineral interest to each of the kids, but to give to one of them, you get 100% of the executive right. So 2 of your kids get a 1/3 mineral interest with no executive right, and one gets a 1/3 mineral interest with 100% of the executive right. All right. So some of the issues that we're going to see legally come up. One is executive right granted when it's not mentioned? Okay, the basic answer to this is 99% of the time, yes. If you grant a mineral interest, the executive right goes with it. So if I give you a half mineral interest, that comes with the right to lease that 50% of the property. It can get complicated though if I own something, other than just a, straight up 100% mineral interest with 100% of the executive right, and we'll see that. Some other issues that arise. What happens when there are multiple mineral interest holders, but then that just one executive right holder? In some ways, that's simpler because the oil and gas company only has to negotiate with one party. But what is the duty of that single party to the other people that have the mineral interest? So again, if I was just trying to kind of a chart to see what this looks like imagine you have your land, and just, this isn't physical land. This is just, the idea is you broke up that mineral interest into thirds. So there was, they're undivided thirds. But then one person has the 1/3 of the minerals and the full executive right to determine how that property is developed. Now that one person, if they exercise that in a way to benefit all the parties, great. But what if they do something that basically brings more benefit to themselves and less to the other two parties? That can create problems, and we'll see how some of those arise. So one of the most basic questions is, does this party who has the full executive right covering all three siblings, do they have the duty to lease that property? That property is only valuable for oil and gas purposes. If an oil and gas company comes and develops it, does the executive right holder have the duty to lease it? Next, what would the standard have to be for that executive holder in terms of how much he or she has to negotiate to help those two others? And we'll see that becomes an even bigger issue with non-participating royalty interest holders. Imagine that you have a royalty that's 1/2 of lease royalty. That's your non-participating royalty interest that you negotiated for. Well, then how much you get all depends on how big the lease royalty is that the person who still owns the mineral interest negotiates for. And so that can create all kinds of conflicts that we'll explore. All right, let's start with the kind of most basic question is, can there be a duty to lease? And we'll see that the Texas courts have been maybe a little inconsistent at times on this one. So in Leslie versus Veterans Land Board, the plaintiff owned a non-executive mineral interest beneath a subdivision. Okay, so we have like a subdivision where there's lots of little houses, and the plaintiff has a mineral interest but no executive right. So the plaintiff will benefit when the minerals are produced because they're his minerals, but the plaintiff can't lease them himself because he has no executive right. So the plaintiff sued the individual lot owners and the developer because when the developer sold the lots, it did so with deeds that prohibited oil and gas development. And you can imagine why, as a subdivision owner or as a house owner, one of these suburban lots, if you don't own the minerals, you want a promise that there's not going to be any oil and gas development. So it might make them more valuable. But for the plaintiff, this is a problem because it means there's no benefit anymore to his owning the minerals. The defendant said, look, refusing to lease by itself is not a breach of the executive's duty. And so with this deed that prohibited mineral development, I'm just basically refusing to lease. Now, this comes from that Bass case that I mentioned. That Bass case, or I previewed, is a case of three brothers. And instead of dividing their land into thirds, what actually happened there is that their parents divided the land that they inherited. They gave each party an actual physical 1/3, but then gave each of their kids, I think it was 3 sons, non-participating royalty interests in the other 2 properties. So imagine there's 3 properties, and the way they share in it is that they each have non-participating royalty interest in the other ones, so that when there's development on that land, they all benefit. Now, what happened here is one of the brothers did have an opportunity to develop oil and gas, but he said, well, I'm only actually going to get a fraction of it because a lot of those non-participating royalty interests means that a lot of the oil and gas is going to go off-site. And the brother said, you know what, I don't want to do oil and gas development right now. It's my property, I'd rather not have it. For those other brothers, they said, well, wait a second, you have to develop it. You owe us this duty. We own a part of your minerals. And the court said, no, there's not just a general duty to lease in every circumstance. However, the court in Leslie versus Veterans Land Board says, you know what? This is too far, because this is not just a refusal to lease. This is a commitment that you're never going to lease. You have a deed prohibiting mineral development. And not only that, it seems like this is motivated by self-interest, because the developer is basically getting a monetary benefit from you not leasing. Okay. Now, I would say that it's not super clear what this distinction is from Bass, because again, Bass seemed to say you don't have to develop just because somebody owns part of the minerals on your land. But Leslie versus Veterans Land Board says, well, maybe you can't prohibit all development if there's somebody else who owns part of the minerals. So those seem a little bit in tension. If you wanted to reconcile them, maybe what you'd say is that, well, a couple things. One is, in Bass, these are brothers, it's their own land. Maybe it wasn't like a monetary benefit that they gained by refusing to lease. Whereas here in Leslie versus Veterans Land Board, it's clear, this is a commercial interest that they're trying to gain by stopping oil and gas development. And secondly, this is not just a failure to lease. This is a commitment in the deed that we are not going to lease, ever develop these property in the future. So maybe that makes it more extreme. But I think what you can take from these two cases is there's some gray area. So if somebody else owns part of the minerals on your land, maybe you don't have to lease right away. Maybe they can't force you to lease. But there are some circumstances in which you might be, as we can see here in this Leslie versus Veterans Land Board, that you can't really, say you'll never lease. And so there might be some circumstances in which you're forced to lease. And we'll hear more about that in the next class. All right. Some other ways as the mineral interest owner that you might try to benefit yourself over the, as the executive right holder, that you might try to benefit yourself over people who have non-executive interests in the minerals. So in this case, the Beals granted this land to MIMS, but they reserved, so that means they held back from their grant, an undivided 1/4 non-participating interest in royalties obtained through leasing. Okay. So they get 1/4 of the royalties obtained through leasing. So MIMS leased to MIMS Jr., his kid, for 1/8 royalty. So far, everything looks basically legit. So what would the Beals get from the reserve? Well, they've reserved 1/4 of those royalties. So they would get 1/4 of 1/8. They would get 1/32. Okay, here's where it gets sketchy. So MIMS Jr., you might think, well, it's odd that they leased to MIMS Jr. Does he have an oil and gas company? Well, not exactly. So he actually turns around and assigns the lease to somebody else who's going to actually develop it for a 1/16 overriding royalty. So what's the problem here? The problem is that clearly the Mimses, if you take MIMS and MIMS Jr. together, they knew that they could get more than a 1/8 royalty here. They knew they could have just leased it to Henderson for a 3/16 royalty. In other words, Henderson is willing to, Henderson knows he's going to have to give the 1/8 royalty to Mims, right? But he's also giving a 1/16 to Mims Jr. So what is really Mims Jr. doing here? Basically, he just reduced the lease amount, which was 1/8, when it could have been 3/16 and leased directly to Henderson. And obviously, a 3/16 lease would have gotten extra money for the Beals because they were getting a quarter of the lease revenues. Okay, it would actually be, they end up getting 1/32, which is 2/64. Here, what they could have gotten is 1/4 times 3/16, which is, right, 1/8 plus 1/16, so 2/16 plus 1/16, and that is equal to 3/64. So 1/32 is 2/64, right? They could have gotten 3/64. So basically, this whole shenanigans with Mims to Mims Jr. to Henderson was kind of to cheat the Beals out of 1/64. So Beals sue Mims and Mims Jr. They said, we should have gotten that extra quarter interest of that other 1/16. And the court says, yep, that's a violation of your duty because as the executive interest holder, you have a duty to the non-executive holders that depend on how you lease the property. And so both Mims and Mims Jr. are liable. Okay? So both Mims and Mims Jr. are liable. All right. So there's another case that's just discussed, also just discussed briefly in your book. It's not, you don't have the full excerpt, but this is Bradshaw versus Steadfast Financial, which is interesting. So in that case, the plaintiff owned half of royalty, so kind of like that Beal, right? Of half of royalty in 1,800 acres. It's not like the Govenda case, not a 1/2 royalty. That would be huge. It's just 1/2 of whatever royalty is given in these 1,800 acres. Steadfast owned the surface and the minerals. Okay, so the plaintiff is going to get half of the royalty, but Steadfast otherwise owns the surface and the minerals. Steadfast leased the minerals for a bonus of $7,505 per acre and a 1/8 royalty. Again, you might think, oh, 1/8 royalty, that's normal, that's fine. Well, as it turned out, in that area, typically by 2015, people are giving much higher royalties. And you might say, like, that seems like a big bonus, and it is. That's a huge bonus. So basically, the accusation the plaintiff made was that bonus is too high and the royalty is too low. Why is that a problem? Well, because as we know, if you just get half of royalty, you don't get the bonus. You don't get the delay rentals, right? You don't get shut in. So you don't get those delay rentals, bonus, or any of those like sort of things that come with the lease other than royalty. So when the executive rights holder negotiates for a big bonus and a small royalty, that hurts you. So the plaintiff says the bonus is too high, royalty too low. Court says, yeah, look, 1/4 was the going rate for a landowner's royalty. It's not in the old days anymore. Now people can get a 1/4 royalty. And in fact, Steadfast received 1/4 offers. So the court says at least the jury should be able to determine whether the lessor is liable for violating a duty to the plaintiff. Okay, here's the other question though. Remember in that Mims and Mims Jr. case, Mims and Beal, in that case, the court said that both Mims and Mims Jr. were liable. So is the oil and gas company that made this offer for a 1/8 royalty potentially liable? And the court says no. Okay, that Mims and Mims Jr., that was a special case because it was, it's a father and son. They seem to be conspiring against the interest of the Beals. Here, these seem to be arm's length parties. So Steadfast leases to this oil and gas company, and may be liable, but the oil and gas company is not liable. Okay, so we know that the executive right holder owes a duty to the non-executive mineral right holder, whether it's non-executive mineral interest or a non-participating royalty interest. But what is that standard of care? Well, it's not very well defined, although we'll talk about it more. We'll talk about it more in our next class. So a lot of times, plaintiffs who are suing the executive right holder will say, really, it's a fiduciary duty. Okay, the executive has to do what's best for the non-executive, even if that's bad for the executive. That's the highest duty required by law. It is frequently required in business relationships. So an agent is often a fiduciary of their principal, right? The corporate officers often have a fiduciary responsibility to their company, to their stockholders. The partners often have fiduciary responsibilities to each other, and that means basically you have to do what's in the other party's best interest because you're really acting for them, even if it hurts you. So obviously, that would make it kind of tough on the executive right holder if there was somebody with a non-executive right, because they would have to negotiate a lease that was the best for that non-executive right holder, even if it was worse for them. Now, on the other side of the spectrum, you might look at just a good faith duty, which just says, well, you can't have bad faith. It might be a little bit difficult to define, but certainly that would allow the executive right holder to negotiate something that might benefit them substantially more than the non-executive right holder. Okay. A lot of times what the courts have instead settled on is this utmost fair dealing standard. And we'll talk about that more next time. But basically that says the executive has to get for the non-executive every benefit that he gets for himself. Okay? So you can't be negotiating for some special benefits for yourself as the executive right holder that you're trying to keep that non-participating royalty interest holder from getting. Maybe another way you could think about that is, what would that executive have received if, or negotiated for, if there hadn't been a non-executive interest holder? So maybe in that Bradshaw case, maybe Steadfast actually just liked a bigger bonus, wanted more money up front, and was fine with a smaller royalty. If that's the case, maybe that is utmost fair dealing, right? Because Steadfast says, look, I would have done exactly the same thing even if nobody was getting half of my royalty. The fact that somebody was getting half of my royalty, yeah, it's too bad, it's money out of my pocket, but it didn't change my actions. I still would have wanted more money up front in the bonus, less money in the royalty, because I want more money up front. Okay. I should note that this standard, every benefit that he gets for himself, can be kind of problematic because obviously, if you're the mineral interest holder with the executive right, and there's an outstanding non-participating royalty interest holder, as in Bradshaw versus Steadfast, that says you get half of royalty. Obviously, every bonus that you negotiate for, every delay rental, those don't get shared with that royalty interest holder. So, of course, you're getting benefits that don't go to that non-participating royalty interest holder. So, I mean, it would be a kind of surprising standard if you had to say, okay, you can't even ask for a bonus. You have to put all your compensation and royalty so it's all shared with the non-participating royalty interest holder. If that was your rule, that sounds a lot like the fiduciary rule, that you basically have to negotiate just to benefit this other person with no regard for yourself. So it's hard. So that can't be what it means. So there remains a lot of gray area under each of these tests. Okay. Finally, sometimes courts talk about having a reasonable regard for the non-executives. So you don't have to put their interest necessarily above your own, but you need to have a reasonable regard for it. Maybe that means more. Maybe that means that even if you would have done it one way yourself, and you really haven't changed anything just because there's an NPRI holder, you still have to take their interest into account a little bit and maybe negotiate for a little less bonus, a little more royalty. Okay, now let's look at an example, and we can talk about this more in class. So think about you are advising a client. Your client is Maria Rodriguez. She's inherited 50 acres. Not a huge plot from her parents, and it is subject to a right of 1/2 of all royalty. Okay, so 1/2 of royalty, so just half of whatever lease royalty is granted, in oil, gas, and other minerals, which was conveyed to Jaime Camarillo by Ms. Rodriguez's parents. Okay, Ms. Rodriguez's parents, or Ms. Rodriguez earns a modest income as a bank teller, and she has expenses for college for a child, plus orthodontic work for another. These two oil companies, Black Dirt and Uvalde, have offered to lease her property. Black Dirt offers $100 per acre bonus and a 1/8 royalty. Okay, so maybe that's standard, 1/8. And then Uvalde says, you know what, here's $25 per acre and a 3/16 royalty. Every other way, these leases are the same. So basically, Black Dirt is saying, here's $100 and a 1/8 royalty. And Uvalde is saying, I'm going to give you a bigger royalty, but a smaller bonus. Just $25 an acre and a 3/16 royalty. Okay, she comes to you in this situation and asks, what should she do? Just think about that for a second. What would you advise her to do? Obviously, the benefit of Black Dirt is more money up front. Potentially, Uvalde gets her more money over time. So obviously, your answer is going to in part depend on how much oil you expect from that well. But often as lawyers, we're not necessarily the oil and gas experts, so we don't know. Maybe we think, they're roughly similar. Well, then you might think, well, ideally, we'd like to get her, that Black Dirt, more money up front because she has some expenses right now that she would like to deal with. So if it's going to be the same amount of money over the lifetime of the lease, might as well take more money up front and a smaller royalty. Okay, but remember, she has given this non-participating royalty interest, or her parents did, to Jaime Camarillo. So he is saying, what's he going to say if she accepts a lower royalty? He's going to say, no, wait, that was not good faith as to me. You did not have a reasonable regard as to my interest, which I wanted a bigger royalty. So the question is, what can she do? One idea would be, well, she should be able to do anything that's mainstream. So if kind of half of people are taking 1/8 royalties and half of people are getting 3/16, either one is fine. They're both mainstream. If everybody's getting 3/16 and there's no 1/8, well, then probably she has to take the 3/16 too. Okay, what about, can she talk to each of them and say, hey, you know what? Give me a little higher bonus or royalty, but she has to ultimately pick the one with the highest royalty because that's what the non-participating royalty interest holder would prefer? And does she have to ultimately put Mr. Camarillo's interest above her own? Right? Does she have a fiduciary duty, or does a reasonable regard for his interest require that? All right. So thinking about that, let's go back a ways in your book to page 465 and talk about the Harris problem. Now you'll recall that the Harris problem was Harris conveyed a ranch to the Smiths and reserved, just like in this Rodriguez problem, just like in the Bradshaw versus Steadfast problem, 1/2 of all the oil and gas royalty paid under the terms of any oil and gas lease on the land. So Harris says, you know what? I'm worried you're going to get a lot of oil and gas. after I sell this property. So here's what I'm doing. I'm keeping 1/2 of all oil and gas royalty. Oil and gas was discovered, and the Smiths negotiate an oil and gas lease, but it has a lot of weird things. It has a bonus and a royalty. Okay, fair enough. Harris doesn't get the bonus, does get the royalty. Doesn't get the delay rentals, so we know it doesn't get either of those. Then there was a question of, there were a bunch of other things. There was a production payment, which was another percentage of production up to a certain amount. There was a top up, a certain amount per month, and then there was a share of production not as royalty. Okay, well, we know that Harris is going to get the royalty. We also determined that the Texas courts say, look, even if you call it not as royalty, it's a share of production free of costs. You know what? That also counts as a royalty. You can call it, again, I gave the example of, you could say it's a salad with a meat patty on it between two pieces of bread. That's a hamburger. Even if you call it a salad, that's a hamburger. Same way, even if you don't say it's a royalty, that's a royalty, and the courts are going to treat it that way. But what about these other two payments? What about this production payment and the top up? Notice probably those don't count as royalty. They're not necessarily just a share of production that lasts the lifetime of the lease. But notice that they're kind of unusual things to negotiate for. And so what could Harris do if, we know that Harris is going to get the royalty and the share of production, but what's Harris's objection going to be to that production payment and that top up? Harris is going to say, wait, why did you negotiate for these weird things in your lease? You could have just gotten more royalty, and I would have shared in all that royalty. And especially it looks suspicious because you have this part that you tried to say was not royalty, even though it obviously is a royalty. So Harris could bring a claim against that, the Smiths, who here, because they own the mineral interest, are the executive rights holders, and say, no, you negotiated for a benefit that doesn't go to me. You're trying to harm my interest in 1/2 of the oil and gas royalty. You got to do a standard lease and give me 1/2 of that royalty. Okay. You may remember how that applies or could potentially apply to the example issue spotter that we did in class just last time. Okay. So another problem that arises is another way that executive rights can kind of get severed out. And this is this Day versus Texland case, again, just excerpted. So in this case, Keaton and Young sold 80 acres to Day Incorporated, but they reserved a 1/2 mineral interest. Okay, again, they said, maybe there's going to be oil and gas development on this land. We're going to hold back from our grant. We're going to give you 100% of the surface, 100% of the executive right, just so we want 1/2 of the mineral interest. Okay. So then what happened is Dale sold some land, 10 acres. Day Incorporated sold some land to the Shoffs, but they accepted Keaton and Young's 1/2 mineral interest. That's good. Okay, what does accepting mean? Accepting is when you tell somebody, part of the property I'm selling you is already owned by somebody else. So it's the thing that you're supposed to do when somebody else already owns part of the property that you're selling. So they accepted Keaton and Young's 1/2 mineral interest. Okay, that was the right thing to do. Keaton and Young still own 1/2 of this mineral interest, so that you don't get that. What else do they do? Day didn't want to lose all of the minerals, so Day Incorporated reserves a 1/4 mineral interest. Okay, so that's important vocabulary. We'll continue to use it throughout the course. Accepting means this has already been removed from the property by somebody else. I'm just letting you know. Reserving is, right now, I am not selling you everything I have even. I'm holding back a little bit for myself. Okay, so end of the day, how much of the mineral interest do Shoffs have? Okay, that's pretty easy, right? There was a full 100% mineral interest, half was reserved by Keaton and Young, and a quarter is reserved by Day, okay? So the Shoafs have just a 1/4 mineral interest, okay? Easy enough. Now the Shoafs lease to Texland, and Texland completes a well. Day Inc. leases to Bobby Day. Okay, question. How much does Day Inc. have? Well, Day Inc. has also 1/4. So we got the Shoafs here with 1 and Day Inc. with 1/4 mineral interest. Okay. Now, what about who else has the other half? Okay, well, Keaton and Young has the other half. So so Day leased his own quarter mineral interest, or its own quarter mineral interest. Shoafs leased their own quarter mineral interest. But who leased Keaton and Young's? Because it can't be Keaton and Young because they conveyed the full executive right. So what happened to that 1/2 executive right, that 1/2 extra executive right that Day had? Now, what are some of the options? Well, so it could be that the Shoafs only got their quarter executive right, okay? They got a quarter mineral interest, got a quarter executive right. And that left 3/4 of the executive right. So the extra half goes to Day. Or it could be that the extra half went with the quarter mineral interest to the Shoafs, because remember, basically Day said, I'm selling you everything I have. You should just know Keaton and Young have the half mineral interest. By the way, it doesn't come with an executive right. And I'm just reserving the 1/4 mineral interest. So maybe that means Day only gets the quarter executive right, and Shoafs get 3/4, everything else that's left over, 3/4 of the executive right. Well, that's what the court ends up deciding. Because the court says, look, that right to lease Keaton and Young's half mineral estate, it passed from Day's to the Shoafs, and they say this is because of the greatest possible estate rule, which is when you make a conveyance, if you don't specify and there's ambiguity, we're going to interpret it as larger. And so the greatest possible estate rule says that Shoafs get their quarter mineral interest, but they get the 3/4 of the executive right. They get the extra half executive right from Keaton and Young. All right. The greatest possible estate rule just says a grant or reservation that is not limited is interpreted to mean the greatest possible estate. So as an example, if you say, I'm going to give a 1/2 mineral interest in Blackacre, and you don't specify executive interest or other rights, courts will usually interpret it as, okay, 1/2 mineral interest comes with a 1/2 executive right. But if you have any extra executive right, like just sitting out there, let's say that you had the full executive right plus a half mineral interest, they will say that extra half executive right, it goes with the mineral interest because of the greatest possible estate rule.